All right, good evening. Welcome to those here live at LACA, Ludington Area Center for the Arts, and those on Zoom. We are here for the start of the 5th topic of the 6-topic series. It's on truth and politics. And it's for those who are new. There are a few people, especially online, new. Shifting Landscapes is a series where we have been examining the rubble from the pandemic, the murder of George Floyd, and many other things that fell out, new information and information we could no longer not see over the past couple of years since the pandemic began. A few more housekeeping details, in addition to the treats in the back for those live, is that tonight we're focusing on the First Amendment, specifically the intersection of the First Amendment and public libraries. Our speaker just earlier tonight, when we were doing a check with her, said, "Oh my gosh, there is so much to talk about," and I was thinking, the First Amendment, and we're only focusing on couple of aspects of the libraries, and there's the whole rest of the First Amendment that we have yet to consider. So it's a huge topic, but thank God it is, especially when we look at what's happening elsewhere in the world and the need to keep strengthening our democracy and keep protecting all of the individual rights that we have. We are funded by the Michigan Humanities, I always still want to say commission, but it's just Michigan Humanities now, and the Michigan Council for the Arts and Cultural Affairs. Both of them have funded us generously, and we thank them. And again, I thank you and myself as fellow taxpayers in this together, and that's where the money largely comes from. This series is produced by a team. Kathy Organ is sitting here live. Thomas Trahey is a member of the team back. Online is Kathy Calabretta, and 2 people who had to leave the team, but I still mention them because they have been spirits behind the presentation, is Matt Sanderson, a philosopher at West Shore Community College, and Mike McKinney, who is the professor of science there and is now retired. And also the library, Sue Carlson is over here, and I also want to thank Eric Smith. He continues as the library director to really invest in this series. A brief preview of next week, which is, we're focused really on the new guidelines from the American Psychological Association. But this focus on masculinity, or the ideology, or as a sociologist would say, the ideology of masculinity, or what does it mean for a boy and a man to be males in this culture? We're focusing on new guidelines that the APA, American Psych Association, developed in 2018. There was some brouhaha once they went public. We will hear next week from a psychologist teaching at West Shore about the guidelines, about the pros and the cons from people practicing, as well as what changes have been made. There is already a forecast of, I think, 10 years from when they started, that they would be under review again. By the way, there are women's guidelines that were adopted in something like 2013 without much hassle. So interesting. But it was spurred by very deep research about white men and how white men 25 to 55 without much college education, low employment or no employment, were dying of deaths of what are called despair in the epidemiology of diseases that are tracked nationwide and actually worldwide. And those are deaths from suicide, harm from drugs or alcohol. So now getting to this evening. It's been an amazing journey for me because I really didn't realize that libraries were as occupied with the First Amendment as they are. It's almost a founding theme for libraries. And there are 2 aspects that I'm going to share with you that I'm particularly have been particularly struck with. And you may find others as we go through this evening, because we're all different and we all find other different things to be super important. One is the freedom to learn. And where does this fit when the First Amendment is about the freedom of religion, speech, press, the right to petition, and a peaceable assembly? It's this cross between, in particular, but all of them, speech and freedom of the press. Because the thinking is, the constitutional lawyers argue, that without freedom, opportunity, access to learn, there can be no real freedom of speech, freedom of expression, nor freedom of the press, or it serves no real purpose. So I got to thinking a little bit about this. This is why we see in February Banned Book Week. This is why Access, our own public library, make sure that they have a night available to people, a Saturday available to people. And most of the time, I think this last week when we were off for roads were too icy for schools, et cetera, I think it was the first time I've known this library to not be open even on a snow day, because they believe in access so much. Also, this series is a lecture demonstration of their belief in lifelong learning. But certainly we also know of access to be able to look at any book we want without restriction. Nobody is over our shoulders to say you can't have that. And that is so really regardless of age by the Constitution. The other one is a version of freedom of expression. And that is, I know the freedom of expression for myself, you know, and for each one of you, we all get to express ourselves, say what we want. But freedom of expression is also about freedom to hear what somebody else is expressing. And that is also a protected right in the Constitution. So I went back to thinking about, you know, how when we had Todd Skipper here and Amanda Nason from the public schools talking about learning and the marketplace of ideas. And that's really what the marketplace of ideas is all about, is exchanging what we think and not just droning out somebody else while they're talking and, you know, figuring out what I'm going to say next to counter their argument. It's really listening to them, asking them questions, learning more about them, understanding more, so that in the marketplace of ideas, we choose what we believe in from a more informed place. And this is what libraries do and what they stand for. And it's so exciting. So let me now introduce our speaker for tonight, Clare Membiela. She is a lawyer for the law library, for the Law Library of Michigan. She came recommended by a number of people who have heard her speak, that she speaks with clarity, that she certainly knows her business, and is just will be very informative for all of us. She's had 30 years of library experience. She's been in this position currently since 2016. She's the library law consultant. There it is, there's the right title, at the Library of Michigan. Prior to this, she was at academic libraries. So in Michigan, she was at Western Michigan at the university's Cooley Law School. And then she also was a law librarian for Miami University in Florida. And prior to that in Florida, she also served as the librarian for 2 law firms. Her academic degrees is an MLS, Masters of Library Science, and a law degree from the University of Miami. Please help me welcome Clare Mirabiella.
Hi everyone. Thank you for inviting me to speak today. I'm going to go ahead and jump kind of into my presentation just to make sure that we have enough time for everyone to see it. So let me go there. And okay, I think we're all set. So there we go. Okay, so I wanted to, you should be seeing my title screen there. And I'm gonna go there to my introduction screen. Here is my contact information. As it was noted, I am the library law consultant for the Library of Michigan. That's the state library here in Michigan. I am.
I'm sorry to stop you. But
Yeah.
we don't see your slide presentation.
Oh no. Okay, let me try this again. All right, I'm going to try this again. It looked to me like you saw it, so that is not great. Let me try more time. Can you see it now?
Yep, that's it. Perfect.
Okay, there we go. All right. There we go. That's better. Sorry about that. Okay, so this is my slide with my kind of introductory slide. It also has contact information, which, you know, if you have questions about what was discussed tonight, please don't hesitate to shoot me an email. I'd be happy to, you know, send you some additional information. I do have a master's degree in library science and a law degree. I have most of my career has been in academia, academic law libraries, teaching law students. The best way to kind of describe my job is I help public libraries with legal issues. So I kind of help them understand legal issues, and I provide them information to help them determine how to respond to certain legal issues and what's required of them. I am not a practicing attorney. I do have a law degree. I have not taken the Michigan bar because I do not have to for my job. So I, you know, chose not to be a practicing attorney. So I am not. That brings me to my disclosure here, which is that I'm going to be discussing legal information tonight, and we're going to talk about several cases and things like that, and legal doctrines, but I'm providing information and not legal advice. If you have a legal situation involving the First Amendment, you will want to contact your attorney. So, as to start off this, I want to mention before I get real deep into it that this is a huge topic, and almost every slide in this presentation could generate an entire presentation by itself. So I attempted to kind of just look at a brief history of, you know, where did this freedom of speech come from, and then look at, through the lens of what I do, which is work with public libraries, how does this First Amendment right kind of intersect and affect public libraries? Now, a lot of the concepts we're going to be discussing are, you know, don't apply just to public libraries. They apply to many other situations too, bookstores and a lot of other things. So it's not, you know, if you're not familiar with public libraries, it's not that this information is going to be so narrow, but we kind of had to narrow it some way, because otherwise it very easily can get away from you. And an hour is a kind of a small amount of time to deal with a lot of these issues in a real thorough way. So I just wanted to make sure. So the information you're getting tonight is kind of a taste. It is not everything, but hopefully it's enough that will get you interested. And in the resources sheet and the resources slides at the end of my slides, there's a lot of information there that if you are interested, you can search them out and read some more and get some more information about it. So this is what we're talking about, the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, I highlighted the particular section we are specifically focusing on tonight, but as we do that, we will kind of slip into some of these others, because as you'll see when we talk about the history, a lot of this is all tied together, which is the very reason the founders put all of this in the same amendment. There's a reason why they put speech and religion in the same place. So first, to talk about the history of the First Amendment, we also have to talk a little bit about the framers. And I'm just going to mention that pretty significant to this whole discussion and into understanding where the framers kind of where their heads were when they were thinking about all of this, is the framers, most of the framers were adherents to a 18th century philosophical movement called the Enlightenment. And the Enlightenment is actually pretty fascinating. And it espoused kind of a more kind of progressive point of view, right? So people who looked at the Enlightenment favored constitutional governments. They favored the separation of church and state, the concepts of liberty, individualism, tolerance, fraternity. And when you look at this, you think, this looks really familiar, right? So this looks a lot like some tenets that have to do with how the United States was set up: constitutional government, separation of church and state. So the framers of the Constitution took the things that were in discussion during that time period and things that were people were excited about, and put that into this document that they were creating. So again, there's a lot more to the Enlightenment. It's actually quite fascinating if you are interested. So framers like Thomas Paine, John Locke, Thomas Jefferson, Benjamin Franklin were all proponents of the Enlightenment. And Benjamin Franklin has often kind of been held up as like the poster child for the Enlightenment. So think kind of like Renaissance man. You know, you think of everything that Franklin did, but he had a very strong kind of adherence to science. So one major part of the Enlightenment had to do with reason, right? So reason drove authority, reason should drive how laws are set up. So in the Enlightenment and the tenets of Enlightenment were a big deal to the framers. And it's important to kind of at least have a little bit of understanding of this when you're trying to figure out why the framers did the things that they did and wrote the things that they did. So the Bill of Rights is a document separate from the Constitution, right? So the Constitution was drafted around 1789. The Bill of Rights was added to the Constitution and shortly after the Constitution was ratified. And in fact, there was a lot of problems with the ratification of the Constitution because the individual states and the colonies prior to the Revolutionary War, or right during the time of independence, so around the Revolutionary War, when there were the Articles of Confederation, which was kind of the pre-Constitution, each individual colony had its own kind of document, right? So it had its own founding document, just like states have their own constitutions now. And those documents laid out for that state and the governments of that state how those individual states and the peoples of those states, the tenets that were important to them, and the philosophies and the types of rights and things that were important to those individual states. Now, Virginia actually wrote a model of this document that a lot of the other states kind of copied, and that document was also the model for this Bill of Rights. There were things in these various states' documents that didn't get into the Constitution. So when the Constitution was drafted, the framers didn't pay a whole lot of attention to individual rights. And part of the reason for that was not because they didn't believe in it. They most certainly did. But they figured that when they wrote the Constitution, they laid out in the Constitution the things that the federal government would be responsible for. And their thinking was that, well, if we don't put it in the Constitution, then obviously that is not something the federal government has anything to do with. So in their mind, it was the federal government did not get involved in individual rights. It was the kind of thing like, well, of course they have those rights. We don't have to lay them out. The states have them laid out. We don't have to lay them out. But the states were very, very concerned about federalism. They were very concerned about this idea of the federal government being able to direct them in certain ways and to be over them. So this fear kind of drove this desire for these bills of rights that laid out certain specific individual rights that these states wanted to make sure were represented. And there's a series of documents called the Federalist Papers, and the Federalist Papers were a series of like pamphlets that were written by some of the framers, including Alexander Hamilton and Madison and John Adams. And those documents actually, the purpose of them was to convince people to ratify the Constitution. So they're arguments for certain sections of the Constitution. And so in reading these documents, you can also kind of get a sense of why they didn't put the individual rights into the original Constitution. The initial draft of the Bill of Rights were written by George Mason and James Madison from Virginia. In fact, James Madison was not too sure about this Bill of Rights, but kind of got talked into it as almost a political move to ensure that he would get reappointed to the Congress. So they finished the documents. It went through the Senate and House, and it got passed. It went through several different revisions. In the original Bill of Rights, the First Amendment was actually the Third Amendment, behind the number of people in Congress and salaries of Congress. So that was kind of interesting. During the discussions, it kind of worked its way to the front. So that's kind of a little bit of history about the actual document itself. We're going to kind of be bringing back into that throughout the night. Let's talk a little bit about some basic origins of free speech as a concept, right? So if free speech came, if the idea of the Bill of Rights came from documents the states already had, well, where did this idea of an individual right of free speech kind of come from? Now, the framers were all British, right? So a lot of the impetus for what they put in the Constitution and what they put in the Bill of Rights had to do with their experiences and historical experiences with the English monarchy. Now, a lot of that had to do with the relationship between the monarchy and the church and the different churches, right? So you have the Church of England, you have the Catholic Church, then you have the Protestant Reformation. So throughout the history of the monarchy and their relationship with the church, in pre-Henry VIII, right? So pre the split and the creation of the Church of England, it was largely dominated by the Catholic Church. And so you had the Catholic Church and you had the monarchy, and the Catholic Church and the monarchy had kind of a tentative agreement between each other. And very often what would happen is, because of politics and, the thirst for power and wanting to make sure that, they had, the property and the access to the people and everything that they wanted, one would end up checking the other, right? So you had this kind of inadvertent checks and balances system because they were separate. And to a large extent, in many ways, not in all ways, but in many ways, it kind of worked. Then when Henry VIII separated from the Catholic Church and declared himself the head of the church in England and created the Church of England, you now had a situation where that kind of separate checks and balance was gone, right? So you had a combination of church and state. And that caused all kinds of problems, particularly with this idea of free speech. So even though in the Magna Carta, right, in what, I think it was 1066 or around there, the Magna Carta was a recognition of some basic rights of people, right? And one of those basic rights included the ability to petition the king, right? Not unlike our constitutional Bill of Rights right to bring grievances to the government or air grievances with the government and petition the government. So these basic rights were laid out very early in England. And because of this kind of checks and balance with the churches and the monarchy, they were not always paying attention. They didn't always strictly enforce restrictions on some of these basic rights that they may have been able to, right? They kind of picked and chose between the king and the church what they clamped down on and what they didn't. And sometimes it was kind of like whack-a-mole. It was like, okay, well, we're having a problem here, so we're going to clamp down on, speech, or we're going to clamp down on what the church says, clamp. So, it kind of ebbed and flowed. So this idea of these basic rights kind of ebbed and flowed throughout the history. But then when you had the separation from the Catholic Church, Henry VIII absolutely had this kind of, absolutely zero tolerance policy of criticism for what he did. He tried, even some of his closest advisors, he would bring them up on trial, he would execute them, he burned books, he burned documents. He just was absolutely, would not hear any kind of dissent based on what he had done, which was kind of a shift in things from what it had been in the past. Now, as time moved forward past Henry VIII, we got into the whole idea of Martin Luther and Protestant Reformation. Part of, in between this time, we had printing, right? So the printing press and the Gutenberg Bible. And so the Protestant Reformation, one of the things that happened in this is Luther made sure that he printed the Bible, right? So, and he made this information available to members of the general public, at least those of whom who could read, right? And this was revolutionary. This changed the game when it comes to free speech. All of a sudden, people had access to information that only very wealthy people had access to before. Now, when this all started to happen, the king and the British Parliament and king started to kind of clamp down and try to monetize some of this, and they had a system of licenses where they would only permit certain publishers to publish, and certain not just anybody could have a printing press and publish, right? So it was controlled, and if you broke the law, there was swift and very severe punishment. Then we had libel, right? So again, as we had the ability to print pamphlets and the ability to print people's interests and news and opinions, you had people saying things about people, and people printing things about people, and people printing things about the monarchy and the state of things and the church. And so that very quickly became, was very clamped down on. And libel law in early England was very, very strict. So they would call it seditious libel. So it would be if you said something against the king or something against the government or what they were doing, you could be brought down for seditious libel. And libel is where, currently in modern law, libel is where you write or say something, well, it's actually write something that is incorrect. So about somebody, like that could harm them. So it's something that causes injury. It's not just anything. It's something that has to cause injury to the person. Now, then we had Charles I, who by all accounts was not necessarily the best king. Charles I, more than any other king up to him, severely clamped down on this idea of licensing, printing, and seditious libel. And he, brought lots of people up on charges. And that's where, he had the Star Chamber. You may have heard of the Star Chamber, where it was like this special, panel, this special court, where they would bring people who had broken the licensing laws or who were accused of seditious libel. And, you know, they were treated again very harshly, executed, things burned. Again, very strict interpretation of the ability to criticize the king. When Charles was executed, shortly after Charles's execution, William and Mary, when William and Mary came along, and there was some, you know, I'm kind of speeding things up. There was some, after Charles, there was another king. But the next kind of big thing that happened was when William and Mary jointly ruled England, shortly thereafter, there was a 1689 Bill of Rights in England. And the 1689 Bill of Rights was more of a, it kind of built on the Magna Carta's recognition of human rights, right, of some human rights. It actually was closer to our Constitution and our Bill of Rights than the Magna Carta was. And so, you know, there's a lot of thinking that this 1689 Bill of Rights is actually the initial template of our Bill of Rights. And one of the things that this did, the 1689 Bill of Rights did, was it finally gave Parliament the ability to speak freely on the floor and to advocate for their constituents and to say things that might be critical of the king or critical of the church without fear of retribution. So that, you know, that was kind of a big deal. In England, generally, if now we're closer to colonial America, okay, so now we're kind of moving up to the colonial period. The 1689 Bill of Rights is kind of the last big thing in England that happened as far as, you know, the free speech idea and the US adoption. So in England during the colonial period, the English press had a lot greater latitude in terms of free speech and got away with a lot more than colonial America did. And a lot of that, it is posited, occurred because colonial governors and colonial governments imposed strict regulation of the press. And again, we had the idea of libel, the idea of, you know, if you criticized even your opponent in a campaign, if you said things, you know, that were offensive, you could be brought up on libel. So, you know, this was kind of the rule of the day in colonial America. You know, if you think like when, you know, Benjamin Franklin was publishing his papers and Thomas Paine. During this period, in the colonies, you had the Zenger Case. And the Zenger Case was probably the first case that looked at freedom of speech and press. And the idea under British law, you know, how far could you go with, you know, criticizing somebody. And in the Zenger case, what it was someone who published a pamphlet, and they called the someone who was running for office some very horrible names, you know, some I think he called him like a it was like an old British insult, like a pennyweight or something like that. And they were arrested and they were, you know, brought to trial. And what the court actually argued that in Britain, because the colonies were under, you know, the British law, they actually said that the defense said that in Britain, there actually is freedom of the press. And there actually is this idea that this person who published this had the right to say what they wanted to say. And the court ruled with them, right? So they actually, the Zenger case, you know, it was actually the Zenger case, Zenger, said nasty things about the governor who was running. So the victory that he had in the court was the first instance of this idea that of freedom of the press. And once they won that, you saw a really big increase in you know, how the press was used in the colonies before the American Revolution. So that's kind of one of the seminal cases that people look at, is that Zenger case, is kind of the very little beginning of American free speech litigation. Okay, so now we kind of have the historical context behind us to a certain extent. And we're going to now talk a little bit specifically, when we say free speech now, and when you hear that term kind of discussed, what is it really that we're talking about? So let's talk about modern free speech, okay? The first thing to know about the First Amendment and modern free speech now is that the First Amendment only applies to government situations, right? Only applies in public. Now, so if you're in a private business, right, you don't have a First Amendment right? Someone can tell you to, please, don't say that, don't curse in a private store. But as soon as you put your feet onto public space, whether that's the lawn of the Capitol or a sidewalk or the street or a public library or a government office or a state building, now you're in a situation where the First Amendment applies. First Amendment rights are not absolute, right? There are limits to the First Amendment. Even though there are freedom of the press and there's freedom of speech, there are some limitations. There are some regulations to freedom of the speech. It's not just a free-for-all. But those restrictions of rights are very often situational. So they're very often dependent on the mission of the entity that wants to impose the restriction, the situation of the person who is being restricted, and how the restriction affects the abilities of others to take advantage of that particular right that is hoping to be restricted. We can say, well, we can do the test, say, for obscenity, and we can think that something is obscene, or we can, say that something is, not protected because it fits one of the exceptions. But the only entity that could really for sure say that something is not covered by the First Amendment is a court. All of the tests that courts give to determine whether something is covered under free speech or not is really meant to be reviewed by a court. Those tests are meant to be followed by a court in order to help them make a decision. So, in any situation, individual people saying, well, you can't do that, that's a violation of my free speech rights, or you can do that because it's not a violation of my free speech rights, are pretty much just kind of guessing, just estimating. The only way to really know for sure is for someone to bring it to court. And this actually kind of came a lot into play during the pandemic, right? Because of some certain special places that libraries have within the realm of free speech, and how far can a library go, for example, to make someone wear a mask? Does the public health aspect trump the constitutional right to information access, in terms of if you're not wearing a mask, you have to get kicked out? It can be very difficult to kick someone out of a library, and we're going to get to that in a minute. So not all freedoms are equal, right? So rights are not absolute, and not all freedoms are equal. When courts consider situations involving restrictions of rights, they employ certain kinds of what they call scrutiny, right? Certain ways of considering some of these tests that in order to determine whether a right has been infringed. Now, scrutiny goes from what we call rational basis, which is the lowest level of scrutiny. In other words, that means that in order to prove that a right is, you know, that you have the right, or in order to prove that you can restrict the right, the bar is lower, right? So the person who wants to restrict the right, it's kind of a little bit easier for them to show that they can do that. Intermediate scrutiny now rises up a level. It gets harder to prove, and the rules and the burdens that the restrictor has to overcome in the law are a little bit higher. And it's a lot of times it's a lot of these censorship cases employ intermediate scrutiny. Not all of them, because again, it can depend on the situation, but there are First Amendment cases that employ intermediate scrutiny. And then you have strict scrutiny, which is the highest. Strict scrutiny is when something is affecting a fundamental right, and that a lot of times, or a protected class, and those would be things like, again, free speech. You're available, you know, a lot of times situations where someone is protesting in the public square, political speech. You know, there are certain kinds of speech that are kind of more protected than others in general. And so strict scrutiny is reserved for those areas. And again, some First Amendment cases in terms of like libraries can also apply to those. So when you're considering, one of the things that we tell like public libraries, or we tell people who are, you know, trying to figure out, well, how do I create policies that wrap around these things if only a court can for sure decide whether something can be restricted or not. And kind of the rule of thumb is that if you're not sure, if you're in a situation, you know, you may have a policy that says, okay, patrons in a library cannot do anything in a library that's going to impede the ability of other patrons to enjoy the library. That's kind of a classic, perfect example of a legitimate restriction of the right, right? So you have a right to information, but that right can be restricted if you are infringing with someone else's right to get information. And that's a policy that a lot of libraries will use for a broad range of things in terms of bad behavior on the side of patrons. Well, if you have a library that's kind of looking at a situation and maybe it's on the fence, they're not absolutely sure if this would fall into that category, then a lot of times we would say, well, if you're not sure, then err on the side of respecting the right, right? So that would mean err on the side of giving the person access, of not restricting the right, because most cases that deal with civil rights tend to say, you know, err on the side of permitting the freedom. Now, one of the side effects of all of this is that these rights can be incredibly politicized. And this has happened, you know, way back to the Magna Carta and those initial, you know, rights of basic rights of humans, basic rights of the British public, British citizens. The church politicized them, the monarchy politicized them, we politicize them, different sides of the aisle politicize them, and that's unfortunate, but it's right, it's just kind of built into humans, right? The one side is going to use what they can to push an agenda, especially when pushing that agenda gains them something like an election or power. So unfortunately, that's something else that you have to kind of look out for, is when someone is imposing a restriction, what is the purpose behind that restriction, right? And that's something else that we tell libraries. When you're creating policies, one of the things to consider is, what is the purpose of your policy? Why do you need that particular policy? Is it just a knee-jerk policy, or is it, you know, a policy that is really necessary? Okay, as we mentioned, there are limits to free speech. We have, so there's about 4 or 5 limits. So you have defamation, and true threats are the first two that we're going to talk about. So defamation is libel or slander, right? So it's either written or spoken information that is incorrect and could harm the reputation of an individual or a company, right? And especially if the person writing or speaking it knows that the information they're writing is false. So that's those words. So if you write something about somebody that you know is untrue, and you just write it because you're angry or because you want to hurt them, you know, that is not protected free speech. And so, you know, for example, in an election, if one party, you know, has a really inflammatory ad that is just, you know, damaging and is totally not true, then that ad could be taken down. That's not, you know, covered by free speech. And then true threats. So true threats are speech that promises that they're going to commit a crime, right? So it could be you know, school shooters writing documents, letters, I'm going to kill this person, I'm going to bring in, you know, my gun and shoot people. Those documents would not be considered free speech. Those would not be protected under the First Amendment. No matter how whether they're presented in a podcast, whether they're presented in print, whether they're presented in spoken word, none of those things would be free speech. And then you have fighting words. So fighting words are a little different than true threats, right? So true threats are like imminent danger, like imminent, you know, you're going to kill somebody. Fighting words is, you know, they term it face-to-face speech. So think two people in a bar or two people in a political debate, right? Or you could even say someone who is protesting or somebody who is, you know, standing on a soapbox and, you know, which is one of the most highest protected speech, but they say something that is so egregious and so offensive to a particular person that it could start a physical fight. It could be certain language, right? So one of the cases that's heavily cited for this is a case called Chiplinsky versus New Hampshire. And this case had to do with again, it's like an election thing where one person said, you know, something nasty to somebody else, and it provoked an actual physical fight. And the court said, okay, you know what? Yes, free speech, especially in public, you can say anything you want, but when you're saying something in someone's face, specifically offensive, specifically to harm them, and saying that has a high probability of provoking a physical fight, that's not okay. Those are not protected. That's unprotected speech. So, you know, part of the purpose of that is obviously, you know, especially, you know, pre-technology, is that it has a high probability of causing a bigger fight. You know, two people fight, then their friends fight, the other person's friends, and it could cause, you know, some public danger. Then you have inciting words. So fighting words are, you know, face-to-face speech, often insults. Inciting words is where, you know, someone makes a speech and is encouraging immediate lawless action. So that would be more along the lines of Brandenburg versus Ohio is the case most often cited for this. And this is a case involving the KKK. And so this was a group of a KKK group where their particular kind of meeting was filmed, right? And then they would show the film. In this film, one of the ringleaders of the group, you know, they would whip the group into a frenzy of essentially hate. And then they would say things like, you know, well, you know, revenge might be necessary, or, you know, somebody needs to take care of these people. And that is interpreted as like a rallying cry to commit an unlawful act. We're going to attack people. We're going to destroy property, anything like that. Anything where you have a situation where a group is being encouraged to break the law. That is called inciting words. You're inciting a riot, right? So that would be, that's also unprotected speech. And so the person could be arrested or penalized for engaging in that kind of activity. And lastly, we have the one that is probably one of the most, used exemptions and the most misunderstood and quoted exemption, and that's obscenity. And the issue with obscenity is that a lot of people think that it's one thing and it's something else. So when you look at obscenity, obscenity has a very specific test in the law, and the test is written on the slide. I'm not going to go through it really in depth because it could take the rest of the night, but it imposes some fairly subjective reasoning to determine whether or not something is obscene. And the thing is that you have to apply all three things. So the work that you're looking at as being obscene has to meet all three prongs of the test, right? So it has to be in the prurient interest, which means it is arouse the sexual desire. It has to depict sexual content in a specifically offensive way, and it has to lack serious artistic, political, or scientific value. So you have to take all of those three things together in order to determine whether something is obscene. When you look at the case law, and when you look at the case that determined this, which is Miller, one of the things that one of the justices said is that this really applies to what you would say hardcore pornography. So one of the things that we tell libraries is that if you can purchase the material in the open market, right, in the legal marketplace, I'm not talking about the dark web, or, if you can purchase this at Barnes and Noble, or you can purchase this at, Amazon.com on their, on their streaming site, then that is not obscene. It may be pornography, but it's not obscene. And that means that it is not prevented by the First Amendment. So pornography is actually legal. So if somebody in a library wants to look at pornography, that's legal. Now, however, different states have different laws that could limit this depending on whether children can see it, depending on whether it's through the internet. Now, things like child pornography or bestiality or those kinds of things would definitely be obscene, right? But, your run-of-the-mill pornography is not considered obscene, right? So people who are saying that in a lot of these book banning cases that some of these books, which are, maybe LGBTQ centered, are not obscene, right? They would not meet the test of obscene. Even if they're graphic, they would most likely not meet the three prongs of obscene. And so a lot of people don't really understand this kind of, the obscenity definition is really specific. And that's something that is, it is something that I think everyone should know. And I strongly encourage you to learn more about that because it is fascinating. I tell people that, I have one of the jobs where I have to talk about pornography. The Shank case. So this case was the first Supreme Court test of the First Amendment right to speech. And this is kind of an interesting case because this centered around, it had happened during the First World War. It centered around a communist, a member of the Communist Party, who started to put out pamphlets that was advocating against the Conscription Act, which kind of like was the draft at the time. And he was arrested, and he actually lost his case because the court said that even though in non-wartime, he probably would have won, this probably would have been held under the First Amendment, the fact that it was war, his actions could have a serious impact in the ability of the United States to get soldiers, you know, to operate and to win the war. And so it actually was, you know, he lost. Now, one of the things that's interesting about this case, because, you know, it's not a good general description or general treatment of the First Amendment because it had that kind of war kind of slant to it. But one of the things that's interesting about this case is the phrase that you may have heard, which says you can't yell fire in a crowded theater. That came from this case, right? So that was one of the justices said, look, you know, you can't, you know, when you have an already kind of, you know, tight situation, you can't, you know, raise alarm when doing so is going to cause greater harm. And so that was one of the reasons why Mr. Shank lost this particular case. So the outcome of this case was that speech normally protected in peace can be affected in wartime. Now we get to the public forum doctrine. And the public forum doctrine, when we talk about, you know, considering whether you know, speech is covered, or we consider, you look at some of these cases, or you look at things like how much can we restrict speech, or can speech be restricted? The public forum doctrine is very important. It was introduced by the Supreme Court in a case in 1931. And essentially what it said is that the public space is divided into three different pieces. So for purposes of constitutional coverage, you have three different kind of public spaces. You have a designated forum or a public forum, and that would be like the sidewalk or the lawn of the Capitol. That's the most protected speech. Then you have a limited public forum, which a limited public forum is a forum that is usually set for a specific purpose, and it does permit some regulation and restriction of speech in order to facilitate that purpose. And then you have non-public forums, which would be, again, government sites that are not open to the public. So think CIA building or FBI building, or even maybe staff spaces in a public library, right? So when we talk about things like First Amendment audits, and you have people coming into the library and attempting to go in all areas of the library, marking spaces as staff-only spaces, you know, limits those spaces as non-public forums, essentially. So libraries are considered limited public forums, right? Libraries are considered limited public forums in that they are designated for a very specific purpose, for study, for the receipt of information. And you can have regulation in a library and restriction of speech in a library in as much, as long as it's narrowly tailored, they say, as long as it's limited to protecting the ability of the library to complete its mission, to allow people to get information. So the case Martin versus Strothers, Ohio, is a case where you had a guy you know, passing out information. A lot of First Amendment cases deal with Jehovah's Witnesses. So this was a guy who was handing out information about Jehovah's Witnesses, and he got arrested for going house to house to give out this information. And the court decided that he had every right to do it. So this is the case that says that the First Amendment includes a freedom of information. It includes the freedom to learn about new ideas. So it includes a freedom to receive information and to pass on information. And that's an important aspect, obviously, for libraries. And then we had Griswold versus Connecticut, which is one of my favorite cases. because this is the case that struck down a state law that prohibited women from getting information on contraception unless they had the permission of their husbands. And this, the court said that the right to distribute, right to receive, right to read, inquiry, thought, and freedom to teach were all covered under the First Amendment. And obviously that's very integral to public libraries. So right now, what's going on with libraries is that we are undergoing a lot of book banning and a lot of attempts at restriction of various types of speech. So you have, one of the most cited cases in this issue is Kramer versus Bureau of Police for Town of Morrison. And this was a situation where you had a homeless man, which was Mr. Kramer. And he was in the library, and he repeatedly had been removed from the library for various infractions of library policy. And those included things like not looking nice, smelling bad, falling asleep, and various types of rules the library had in place. Now, the court said that public libraries, that there is a right to information and that public libraries are uniquely situated to assist and allow people to express this right. So this pretty much said that public libraries, people have a right to a public library. People have a right to access a public library. It also said that libraries are limited public forums and can implement reasonable regulations. And it decided that in this case, the reasonable regulations were acceptable, and that even though the library denied this homeless man the ability to access the library, the reasons they did so were in keeping with the ability of other people to use the library. But this is from this is a 1992 case, and one of the things it also says is that these policies have to be very carefully structured, right? And they have to be content neutral, which means they cannot involve the content of speech, right? And this gets into things like displays, collection development policies, which are the policies that libraries use to purchase materials, to decide what materials to purchase. So a library can't only decide to purchase, to not purchase a book solely because of its content. They use multiple metrics to decide whether a book should be purchased or not. You have to be careful about restricting access to a library, and there are multiple cases on that. Nast case involved someone who refused to wear shoes in the library, who was barefoot in the library, and said that they were a Wiccan and that it was part of their religious tradition and that they had a religious right to go barefoot in the library. They were actually, the court ruled against them, but there have been subsequent cases where the courts actually ruled for them. And there's been other cases, including here in Michigan, where libraries ended up settling because, the Justice Department or other kind of federal agencies would get involved and would encourage that, because again, a lot of whether you're going to win or lose in these cases can depend on individual situations. And when you're talking about religion, you're talking about things like, do you have a strongly held belief, and those kinds of things. So it can be very situational. There's cases involving libraries or municipalities that bar sex offenders from public libraries. Those have been struck down as being too narrow. So even a sex offender has a right to information in a public library. And again, like I tell libraries, access, you restrict behavior, right? So you don't restrict access, you restrict behavior. Someone can come in the library and look at anything they want, but if they behave badly, right? So if their actions are inappropriate, they can be removed, or if they affect other people's ability to use the library, or in the cases of obscenity, if they're violating a state law, like in exposing children. Meeting room access is a big one. You cannot invite the Democratic, candidate for office to speak in the library and not permit the Republican candidate. You can't permit a very the ACLU or Black Lives Matter to be in your library and then refuse a very right-wing entity from using your library, even if they're white supremacists. You can do other things in the library to mitigate any harm or speech. You can also regulate behavior, but you can't say you can't use this room because you're white supremacist. That's not acceptable. It is distasteful. And I have 2 college-age kids that constantly argue this with me. So a lot of times I'm kind of looked at the bad guy here, but that's the law. You cannot, based on the First Amendment, you cannot make rules or decisions based on content of speech. Patron speech and dress. You can't bar certain t-shirts. You can't say you can't wear that t-shirt in the library, no matter what it says. You can't. Now, if again, you have an obscenity issue and you're pretty confident that it would meet those 3 tests, then you might have a shot. But I would definitely check with your attorney before you implemented a rule like that. You have to treat everybody the same, right? You can't say you can't photograph in the library, but you nice couple on vacation who just want to photocopy the view out the window, you can. You can't do that, right? So either everybody can photograph in the library with certain rules or nobody can. You can't selectively enforce your rules. And this applies to things like noise and public displays of affection, right? You can't not permit teenagers to have public displays of affection, but then permit, adults to do it. Now, again, this is situational, right? So again, we're looking at, if you're into obscenity, then, that's a problem, or public, nudity, or, anything that breaks a local law would not be acceptable. But if you're talking about, 2 teenagers sitting next to each other on a couch with arms around each other, or, again, you can go back to the idea that if it interferes with others people's ability to use the library, then it can be, you can regulate it, but you just can't regulate it because you don't think 2 teenagers should have their arms wrapped around each other. Book challenges. This is Board of Education, Island Trees Union Free School District versus PICO is the seminal case involving schools and book challenges. And this pretty much says that school boards can't remove books from shelves just because they don't like what it says, right? You can have curriculum requirements. You can restrict your collection to match your curriculums, but you can't say, we're not having these books that discuss LGBTQ issues because we don't like LGBTQ, or we don't like critical race theory. You can't bar books just because the people who are making the decisions want to impose their personal views, because nobody has the right to tell anybody else what they can read. Libraries are for everyone, whether they pay taxes or not. And incidentally, if someone's in an apartment, they're paying property taxes. Whether they hold controversial beliefs, no matter how they look or dress, right? So if someone comes in and they're very sloppy, as long as they're not affecting other people's ability to use the library, that's okay. As long as it's safe. So, again, that's one of the questions in the barefoot case, is whether walking around barefoot is going to be a liability for the library and the person walking in barefoot. So that was a reason why they actually voted or rather the court ruled in favor of the library. Now, that doesn't mean everybody can check books out, right? Libraries can have rules for their the communities they serve and whether someone can check books out, but in terms of letting people in, you have to let everybody in. So libraries should not impose rules that limit access to the building. So permanent patron bans is a big one. You cannot permanently ban a patron. You cannot take away their right to use a library. You can't really prohibit pornography. You can limit it, and you can go by your state laws. Like you can limit the computers, especially if they're an open site. Again, this is a situational thing. You'll want to talk with your attorney. You can't tell a kid that they can't check out an adult book, right? You can, but you might be looking for a fight down the road, because that is also not appropriate under the First Amendment. And that is something also the ALA will tell you. You can't limit movies, right? So you can't tell a child they can't check out an R-rated movie, right? You cannot have rules that limit the ability of people to access information, and that includes children. The theory is that parents should be determining what is appropriate for a child to read, what their children should be reading, and what their children should be watching. It is not appropriate for anybody else to make those decisions. And of course, limiting access by viewpoint or speech. And I apologize for that typo. I ran spell check a few times and it did not pick it up. And we are just about done here. I want to mention the Patriot Act because I had a specific question on it. So something important to know about the Patriot Act, and the Patriot Act was it was a amendment to a law called the FISA law, which was a foreign. It had to do with foreign information on foreign, like foreign affairs and defense. The Patriot Act, right after 9/11, the Patriot Act passed, and what it did is it made it easier for the FBI to get access to certain documents and certain information. Prior to 9/11, there were very specific industries that were noted in the act. The Patriot Act expanded that and specifically mentioned libraries and bookstores. And this was something that caused, like the American Library Association and libraries all over the country, a lot of consternation, because almost every state has a law that specifically restricts access to things like patron records, what you are reading, what you've checked out. And that's considered, you need a warrant to a court order to get access to those information. And this law said that the FBI could get access without a court order. They had to follow an internal process. Now, this law was set up so that it had several sunsets, right? And a sunset means the law gets expired unless Congress actually goes ahead and reinstates it, right? So it proactively reinstates it. And Congress did reinstate it several times. In 2020, it was up for another extension to its sunset, and Congress declined to extend the sunset. So that meant in 2020, the Patriot Act expired and the language reverted back to pre-9/11 language that only applied to certain industries, like the transportation industry is one. And that removed that section 215, it was called, from and I apologize, I have the wrong date here. It's actually 2020 amendment, not 2015 amendment. I'll correct that. So that when that happened, that removed what they called section 215 from that that section of the United States Code, and no longer were libraries included. So right now, it's a non-issue. Libraries are no longer subject to the Patriot Act. Now, that doesn't mean that library records can't be, the federal government couldn't get a warrant for library records, but they'd have to follow the same court procedure that the police or anybody else would have to follow in terms of getting access to those materials. So these are my resources from a variety of places. You have the handout. That is what I had. I hope that was interesting. There's a whole lot more that we could discuss, but unfortunately, it's a huge topic and not a huge amount of time.
Thank you, Claire. It's very interesting discussion. I know I myself learned some historical material, which I wasn't expecting to do and love, and then some more very current material. Are there some questions first? here in the audience. So Nathan, if you'll come up all the way to the front.
Thank you very much for your presentation. I'm curious, who brought the lawsuit Kramer versus Morristown? Who was behind that appearing before court?
It was the homeless man. Mr. Kramer brought it.
And just a point of clarification, when you were saying about that the sunset was not extended in 2020, was that specific to the Patriot Act as it related
Yes.
to libraries? Thank you.
Yes, yeah, well, the Patriot Act, that whole amendment, that was the Patriot Act, was not extended. So the language reverted to the same language that act that had been amended by the Patriot Act. It reverted to the language that it had prior to 9/11, before the Patriot Act.
Let me ask this question from online, just a second, Peg, and then because it is a question related to the Patriot Act, which is the question is, why did the Patriot Act so focus on libraries to begin with? What were they afraid of? And then there's a second part, but I'll let you answer that one first.
In general, I believe what I've been able to find out is that one of the things that, so the Patriot Act covered not only libraries, but also bookstores. And I think at one point in the investigation of 9/11, several of the hijackers who were learning how to fly planes had obtained materials from local libraries, and including academic libraries and bookstores on, how to fly planes and how planes worked and all that kind of stuff. So that was the kind of the mode of that particular type of investigation. And that's actually not the FBI actually, prior to individual states implementing library privacy acts in the 80s and the early 90s, there was actually lots of indications of police and federal law enforcement using library records to investigate international incidents and international possible like espionage cases and things like that, particularly where it had to do with the Russians and the stealing of, academic secrets and technology.
Peg, did you have a question? Yeah.
I'm not sure exactly how to state this, but we hear so much about free speech, but we hear so little about accountability for what people say when they're exercising free speech. Is there anything in place in terms of holding people accountable for what they say?
Well, essentially, I guess the quick answer is no. The idea is that, the only way that, it depends on the situation, right? So if you have someone on, television or social media that are spreading, lies or, serious misinformation, then it is possible for someone else to bring suit against them. So they can be, they could be sued for damages for if their misinformation harmed somebody and it is known misinformation and the misinformation was intentional. So if if the case meets those different tests, then someone could sue them and prevail. Unfortunately, a lot of the First Amendment kind of accountability happens through the courts.
Okay, I have another one online. This one is, how are so many people now challenging books in schools? Is it more related to school curriculum than libraries? Are they within the law?
So there's kind of multiple things there. So the attempted book bannings are happening in libraries and schools. And one of the things that's driving them, there seems to be two different things driving them. One of the major things driving them is the current political clashes that are occurring in our country, and the disagreements between the two sides of the aisle on various issues. There are several nonprofit advocacy groups on both sides of the aisle, primarily the more right-leaning sides of the aisle, that have decided that this is a good time to kind of push the agenda of you know, their issues and problems with LGBTQ community and the 1619 Project and the idea of, you know, racial history and some of these other topics. And they compiled lists of books that they feel kind of set an example for what they feel is harmful information. And they started spreading it on social media. A lot of people, including PTA groups and other groups, picked up on this, and then they would bring those lists to their boards of education and demand to know if these books were in the library. So social media has had a huge influence in a lot of this, not all of it, but a lot of it. And then the other side, the other part is that there are also several individuals that are, you know, becoming aware of some of these issues based on, you know, they're being talked about widely in the media, again, on both sides of the aisle. And, you know, they're questioning for themselves and their family whether or not this is something that they want. And, you know, every library and every school district should have policies that talk about how they deal with this, because it's not uncommon. You know, ever since libraries have started and ever since schools have started, there have been people that have complained about various things and complained about books. And usually, you know, there's policies. The difference now is the kind of the virulence that this is occurring with and the sheer numbers. The American Library Association Office of Intellectual Freedom has said that they are experiencing 60 to 70% increase in people reporting problems across the country. And that's huge. And then in addition to that, what makes this particularly concerning, and I think even no matter what your political leanings are, you should be concerned about this. The legislatures of several states are introducing and passing legislation that are further limiting and banning certain materials. And that is, I find, especially scary. And, you know, again, I have two college age kids who argue with me all the time that, you know, some materials shouldn't be permitted. And their feeling is that material that is more, you know, on the extreme right side. And what I tell them is, you know, you don't ban any material, because once you start down that road, before you know it, your stuff's getting banned. So, you know, it is, you know, a very, very slippery slope. And I think a lot of the reason why it's happening now, more now, is because of just, you know, the political climate that we're in right now. But it, you know, there have been fits and starts over the years. Several years ago, you know, in the 70s, there was a big rash of book banning. So I think it again kind of goes up and down, but now we're seeing things that we'd never seen before, like these state laws and things like that. And yes, you know, you can question anything. That's part of our culture. Anybody can go up to a public library and say, I want this book banned. The difference is how the institution deals with it, and whether the institution, you know, complies. And that's where you get into a First Amendment problem. It's not the asking that's the problem. It's how the institution that is, you know, handling that book ban, and how, again, one of the problems is, again, behavior. You know, it's one thing to ask, it's another thing to bombard a library or a school board with, you know, racial epithets, or with, you know, profanity, or, you know, accost them outside of their workplace, or follow them to their cars, or, you know, so that's, again, one of the things that is occurring now. Is it's not, you know, asking is fine. Saying you want to ban something is fine. But if, you know, the methods that you use to go about it are problematic, then that's not okay. But that's also not free speech.
Okay, I have another question online, and then Denise will go to you. Okay. So this is also from a fellow librarian. She says, thank you very much. Enjoyed it. Claire, can you tell us about the challenges facing librarians in Idaho regarding jail time for librarians that circulate quote unquote obscene material?
So most states have a law that prohibits people from circulating obscene material. And in Michigan, it actually says obscenity and pornography to minors. Different states' laws word this differently. in many states, including Michigan, there's a specific exemption carved out for librarians and teachers, so that if you are disseminating information that could fall into this category and it's in the course of your business or your work or your curriculum, then you are not subject to arrest. But there are states that either had that as a law and the legislature changed it, or is implementing that law now. Some states are getting rid of their exemption for teachers and librarians. So what's happening in Idaho is they are implementing a law that would now make teachers and librarians liable for prison time and fines if they participate in providing what is, under the statute, what is defined as, inappropriate pornography, obscene material. But again, you have to look at how the statute defines obscenity or pornography. And if the statute is following along with the federal definition of obscenity, many materials would not fall into that category. So it kind of depends. And then it also depends on the local prosecutor. They're just, someone could bring charges and the local prosecutor could say, I'm not gonna, prosecute this librarian because a kid checked a book out. I'm not gonna do it. There are, lots of kind of steps in this process. But that being said, it is very scary, and it will have the effect. And I think it's the desired effect of libraries will be fearful of collecting certain types of material. And again, that will limit the sphere of available knowledge. And that's sad. And that kind of goes against the intent of the First Amendment. But, again, what are you going to do? You can't have your employees willy-nilly going to jail all the time. So libraries going to have to do what they're going to have to do.
Okay, we'll take one more question. We're at 8:30, but I've noticed that this has generated this topic more questions than most of the session. So it's very interesting. Denise?
I wondered if authors have any say over what happens to their books. For example, the Dr. Seuss Foundation just made the decision to no longer publish 6 of its books due to, quote, racist imagery. But at this point in time, probably tens of thousands, hundreds of thousands of these books are out there. So if they're on our library shelves, can the Dr. Seuss Foundation say, we don't want you to lend those anymore?
They can, but they don't have any control. Once, so a book is a physical item as well as the ideas inside of it. So once you have a physical item, that is property owned by the library, and the library can do with that property as it wishes. And if the library wants to keep that property on the shelf, then that's the library's prerogative to do so. The foundation could put out information to libraries saying, look, this is why we don't recommend this, and this is what we would suggest. And librarians who choose materials for libraries to purchase, this is a kind of a science and an art together. They review a lot of things. They review reviews on the book. They reviews what scholars say. They review what editors and authorities in different fields say. It's not just an individual librarian saying, I like this, I like this. There's a lot of work that goes into determining whether or not you're going to purchase certain books. So that's something that a librarian would take into account, that message from the foundation, as well as other factors, including the demographic makeup of their community, how often those books are checked out. There could be a lot of different factors that go into whether or not a library is going to heed that message. But there's no, the publisher can't make a library take it off the shelves.
All right. Well, quite an evening. Claire, thank you very much for joining us. And thank you all. We'll be back here next Monday night, March 14. Yes. And we'll look at the psychology of men and how we teach men and boys to be who they are. Thank you very much. Do take some treats, those who are here live, take them home or have another cup of coffee if there's more coffee back there. And thank you very much for coming. I hope you had a good time and good night.
Thank you.